All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina.
May I have the court?
Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the Court of Appeals. Your panel today is to my left, Judge Carolyn Thompson, to my right, Judge Michael Stotting. My name is John Tyson. We have one case on the docket today for arguments, Ortez versus Penn National Security Insurance. Before we get started, are there any preliminary matters to come before the court?
Not from the appellant, Penn National Security, Your Honor. Your Honor, we have a motion to strike the memorandum of additional authority that was filed, and our objection to the motion to supplement the record on appeal. I don't know if the court wants to address that orally or simply deal with that at a later date, but that is one thing that's pending.
Okay. I think the court, if the court has questions about those matters, we can certainly bring those up during your oral argument, and you can address them then, okay?
Thank you, Your Honor.
I'd like to thank our court staff, our clerk, and our marshal for being with us today. And nothing else appearing, we'll hear from the appellant. Good morning.
Good morning, Your Honor. Good morning, Your Honors. Good morning. May it please the court. My name is David Brown from Greensboro in the Guilford County Bar. I'm here with my law partner and my wife, Martha Brown, and we have the pleasure of representing defendant appellant Penn National Security Insurance Company. And we come to the court today to ask this court to reverse the order of the trial court, finding that there was coverage under the Penn National policy, and then in turn finding that the Penn National policy limit did not apply, rather that Penn National owed $9.5 million on a $1 million policy, and also that $9.5 million was subject to troubling under Chapter 75, and doing all of that on a Rule 12C motion for judgment on the pleadings without any developed discovery, much less a trial, contrary to all the cases that have found an unfair trade practice in a similar context or otherwise that resulted after a trial, after a full set of discovery, after a full airing of the evidence. And so we come today asking the court to reverse the order on that basis.
Now, based on the filings that the court received, I think the issues that are now before us have narrowed. Is that correct?
Yes, Your Honor.
Would you take just a moment to just, from your perspective, and I'll give counsel the same opportunity, what is exactly left now before the court for us to decide?
Thank you, Your Honor. So the first issue that I think the court has to address is the duty to defend question. Did Penn National have or not have a duty to defend under the policy? And now, as the court is aware, Penn National has reached a resolution with Estes, the tort plaintiff in the underlying case, that has resulted in the judgment against Ortez being marked satisfied. I think that is in large measure moot because Mr. Ortez, the record shows, did not incur any defense cost. He, in fact, never tendered the lawsuit to Penn National for defense. The judgment against him of $9.5 million plus interest has now been satisfied and marked satisfied. So I don't believe that there is anything more to be heard on that. It's an interesting issue, fully briefed, happy to discuss it. But candidly, now that Mr. Ortez has been fully released, I don't think the breach of contract claim survives. Now, Mr. Ortez's counsel has made the point that he could still proceed with his unfair trade practice claim. I mean, we would argue, I guess, several things. One, the predicate for that is now gone because he has no damage. He's been fully released and judgment against him discharged. Furthermore, this whole case, as I mentioned a few moments ago, started with a motion for judgment on the pleadings, even though the answer denied all of the material allegations in the complaint. And the trial court, nonetheless, on Rule 12C, decided to go ahead and, if you will, make jury findings. So we've always thought that was improper. So having said that, in direct answer to Your Honor's question, Our position would be that the breach of contract claim is now moot because Mr. Ortez has been fully released. He incurred no defense cost. If he wanted to try to proceed with an unfair trade practice claim, we don't believe the predicate for that exists, but I think the court theoretically could remand the matter to the trial court and say the Rule 12C motion was premature to rule on that, and given this development, we'll remand it back to the trial court for further proceedings to see if Mr. Ortez can prove an unfair trade practice claim in some other way. Of course, Mr. Ortez also had a bad faith claim that was not subject to this appeal that was then dismissed without prejudice on remand. I suppose he could try to prove whatever he wants to try to prove on that claim. In other words,
So that issue's not before us.
it is not, the bad faith claim is not before you.
Okay.
But it's a claim that was, frankly, it's the reason we didn't get to argue the appeal a few years ago, because the court deemed it to be interlocutory because that claim was still existing. And now, after remand and discovery, that claim has been dismissed without prejudice.
Now, you're here on a Rule 54B certification, right?
Well, no, this is now a final order. There's now a final order.
Final order.
Yes,
Okay.
there was a Rule 54B certification by Judge Nobles in the first appeal. So I guess let me back up and try to be more clear. In 2019,
So let me just ask a direct question. Is the posture of the case today with the settlement that was just happened, that's a final judgment now? Is that your point, or is there still something predicate to that?
it was already a final judgment.
Okay?
It was already a final judgment. So in 2019, the trial court entered an order on Rule 12C granting the judgment for $28 million. Judge Noble certified that under Rule 54B for immediate appeal. We appealed after briefing, and the case called for oral argument. There was a motion by Mr. Ortez to dismiss the appeal on the grounds that, notwithstanding the Rule 54B certification, it was interlocutory and had to be remanded. This court then granted that motion, dismissed the appeal, sent us back to the trial court.
That was a prior panel.
That was a prior panel.
Okay.
Sent us back to the trial court, where we then conducted discovery on the remaining claims. All those remaining claims with Estes were resolved. The remaining claim with Mr. Ortez was solely his claim for the tort of bad faith in claims handling, and that was dismissed without prejudice. So that gave us the right to come back to the court now on a final order, finally appealing the 2019 order now that everything was final.
Okay.
In the interim, the resolution with Ms. Estes and the fact that Mr. Ortez has been fully and finally released, from our perspective, means that there's not much left of the case, and certainly not a breach of contract claim left of the case. That is, the $9.5 million portion of the judgment against Penn National plus interest should go away because we've now satisfied that, and that we don't believe there is unfair trade practice, but if this court were to want to remand it and see if Mr. Ortez could independently try to prove that, I think that's an option available to you.
Now, Mr. Brown, I neglected to ask you if you wanted to reserve time for rebuttal.
Thank you, Your Honor. I advised earlier I was going to reserve 7 minutes, so I think the clock will guide me accordingly, I say.
Thank you.
Thank you.
Okay, so where we are today.
So where we are today is that there was Mr. Ortez has been fully and finally released. And so let me just kind of give a brief background on how we got here. So this all arises out of a motor vehicle accident in 2017 where Mr. Ortez and Mr. Estes were working together, working for a company called Kitchen Lighting and Design down in Jacksonville. Mr. Ortez was the driver. He was at fault in the accident and was Mr. Estes unfortunately died as a result of his injury sustained in the accident. Mr. Ortez Penn National was the liability insurer for Kitchen Lighting and Design. So Penn National's named insured was Kitchen Lighting and Design, the company for whom Mr. Ortez and Mr. Estes were working at the time of the accident under a business auto policy. So the first question was, would Mr. Ortez qualify as an insured? And he would, because he's driving in the course and scope of his employment of company vehicles. There's no question but that, as an initial matter, he comes within the insuring agreement of the policy. And as the court knows, in any insurance coverage analysis, question one is, is the person seeking coverage an insured? Do they come within the basic framework of the policy? Mr. Ortez did. As I said earlier, he never actually came to Penn National. He never tendered the claim or the suit to Penn National, but Mr. Estes' counsel knew that Penn National was the liability insurer for kitchen lighting and design and advised Penn National of the accident and later of the lawsuit. So the next question becomes, is there an exclusion in the policy that applies and affords coverage? And Penn National's position, as the court well knows from the briefing, is that there is a very clear exclusion in the policy, a fellow employee exclusion. It's on page 60 of the record, and it plainly applies to bodily injury to any fellow employee of the insured arising out of and in the course and scope of the employment. So that's what Penn National knew prior to the lawsuit being filed. They knew Ortez and Estes were co-employees, that they were in the course and scope of their employment, and that Mr. Estes died as a result of injury sustained from Mr. Ortez's operation of the vehicle. Mr. Ortez pled guilty criminally to careless and reckless driving, and then the lawsuit, the wrongful death lawsuit, was filed. When the wrongful death lawsuit was filed, it was very interesting. The complaint was filed against Mr. Ortez and against another driver on the roadway, okay? So the allegation was that Mr. Ortez was grossly negligent in not seeing the vehicle in front of it, but the vehicle in front of him was going too slow and clogging the roadway, and they combined to come for the accident.
So the other driver, the other defendant, was the driver of the tractor-trailer?
Correct.
That was in front of the box truck?
Exactly. That's exactly right. And so the complaint, of course, begins at page 85 of the record. The complaint very conspicuously doesn't say that Estes and Ortez were co-employees, but nor does it say that they were not co-employees. It just simply says that they were riding together in the box truck at the time of the accident, et cetera. So then we have to turn to what the actual claim was against Mr. Ortez, and I think this is critical. Our Supreme Court, in both the waste management case and in the Hardersville versus Buzzoff case, has articulated quite clearly the duty to defend standard for a liability insurer, and that standard being that you look at the allegations of the complaint, you look at the allegations of the policy, you don't need to consider kind of factual background or extraneous things. You look at what led to the cause of action. And I think now Chief Justice Newby's opinion in Hardersville versus Buzzoff makes that quite clear, that you look at what exactly was the insured sued for. So on page 100 of the record is the one and only claim for relief against Mr. Ortez. And that claim is a claim for reckless, willful, wanton conduct. And in paragraph 53 of the complaint, it alleges that defendant Ortez is liable to the plaintiff based on the legal precedent of Pleasant v. Johnson. That's the claim. And so if one looks throughout that claim for relief, what you see is no allegations of negligence, only willful, wanton conduct. Why? Because in Pleasant versus Johnson, our Supreme Court in 1985 wrestled with a very fundamental issue, which is if an employee is hurt on the job through the actions of a co-employee and the injured employee gets workers' comp benefits, can that injured employee still maintain a lawsuit in tort against not the company, but the co-employee? And prior to this Pleasant opinion, the answer had been no, that if you get workers' comp, you can't sue your employer, you can't sue a co-employee, all you get is comp. And what the Supreme Court said in Pleasant is, well, you can sue a co-employee, but only under very limited circumstances. And the limited circumstance is if the co-employee is guilty of willful, wanton, reckless conduct. In fact, the very beginning of the Pleasant case, authored by Justice Mitchell, says, the pivotal issue in this case is whether the Workers' Compensation Act provides the exclusive remedy when an employee is injured in the course of his employment by the willful, wanton, and reckless conduct of a co-employee. We hold that it does not, and that an employee may bring an action against the co-employee for injuries received as a result of willful, wanton, reckless conduct. So that was a big change in the law, a limited change because it's really hard to prove willful, wanton, reckless conduct by a co-employee, but at least it did crack the door open to an employee being able to sue a co-employee when they're both injured on the job.
Now, I think the precedents are, do you agree that the precedents are well established that a carrier has a higher duty to defend than they do to indemnify?
There's no question that the duty to defend is broader than the duty to indemnify, but again, I would point the court to Justice Newby's opinion in Buzzoff, because the interesting question is, why is that true? That is, why is the duty to defend broader than the duty to indemnify? And the reason is, as explained in that Supreme Court opinion in Buzzoff, is because of the factual narrative that gives rise to the duty. So there's not one policy that says this applies to the duty to defend. It has, a second policy that says this applies to the duty to indemnify, and it has exclusions. The difference is that the duty to defend is measured by the allegations in the complaint, which may be false, may be groundless, may be barred by the statute of limitations, who knows, but the insurer still has to defend even if the allegations are false and groundless. But the same insuring agreement, the same exclusions still apply. So there's not a separate policy. Indeed, what's always been of interest to me is that in both Waste Management and in Hardeeville, the two kind of seminal cases we have from our Supreme Court on the duty to defend standard, the ultimate holding of both of those cases was that the insurers did not have a duty to defend based upon a policy exclusion, okay? So our Supreme Court has made it clear, just because somebody might be an insured or even that the insuring agreement might be triggered doesn't mean there's a duty to defend if an exclusion applies. That was the holding in both of those cases.
Okay, now, are you claiming that the allegation in the complaint referencing to Pleasant versus Johnson was insufficient to put you on notice that they intended to assert a claim under that?
No, our position is that the fact that the claim was based on Pleasant versus Johnson dovetails directly with the fellow employee exclusion in the policy. In other words, that the one and only claim asserted against Ortez is a Pleasant claim, very specifically and very explicitly for willful, wanton, reckless conduct.
Well, on the same thinking though, if your insured is the company, the employer, doesn't that in fact include any employees of that employee? Agreed.
And we don't dispute that Mr. Ortez was an insured. We don't dispute that.
So how does the policy exclusion then, if there is coverage, and by extension a duty to defend, how does the exclusion square with Pleasant versus Johnson in giving the plaintiff a right to assert the claim?
Great question. So I think the first way to answer that is to walk through how the insurance policy works. The first question is the person seeking coverage an insured? We don't dispute that Ortez was in the course and scope of his employment driving a company vehicle. He qualifies as an insured. Okay. So therefore, he's covered under the insuring agreement. Question two in the duty to defend analysis is there an exclusion that applies that would bar coverage?
Now, is your client also the workers' compensation carrier as well?
We did not carry workers' comp. We knew that there was a workers' comp claim being paid, but that was not us.
Okay, so basically there was a workers' comp claim that was filed, and that's not before us today either?
Correct.
Okay.
Correct. But getting back, I want to make sure I'm specifically answering your question. So Penn National, I think, has to look at the four corners of the complaint and say, what is the claim against our insured? That claim is a claim under Pleasant. What is a Pleasant claim? A Pleasant claim is, by definition, an employee versus employee claim.
In an allegation of Wilton-Walton conduct.
Correct.
Right.
Correct. And again, in paragraph 53 on page 100 of the record, it's very explicit, could not be more explicit. This claim for relief against Ortez is brought under Pleasant v. Johnson. And what is Pleasant v. Johnson? I mean, I just read it. Justice Mitchell said it's an employee versus employee claim for willful, reckless, wanton conduct. So the claim against Ortez is a Pleasant claim for willful, wanton, reckless conduct. So then the question is there a policy exclusion that would apply to a claim by one employee against another? And the answer is yes.
Does that bar all claims or just negligence claims?
That bars all claims.
So your position is the exclusion of the policy is an absolute bar?
Correct.
Okay.
And barred the duty to defend in the same way that the exclusion in waste management barred the duty to defend the insured in that case, even though the insured was covered under the insuring agreement, in the same way in the Hardeeville versus Buzzoff case, that even though the insured was covered under the insuring agreement, the exclusion barred coverage. Same analysis here, that yes, Mr. Ortez, undisputed, was insured. He was driving a company vehicle, working, he's covered. And so if somebody else, if he had hit a pedestrian or somebody else and they sued him for ordinary negligence or even, for reckless negligence, he'd be covered, right, for that claim. But he's not covered for a claim by a co-employee. And I think we cited the cases in our brief, the State Farm case and others, that make it very clear that our appellate courts have consistently over the years enforced the validity of that employee versus employee exclusion. And why? Because there's comp. That's a comp remedy that the employee has. So I guess just to kind of wrap that up in a bow a little bit, what I would say is that our position is that there was no duty to defend based upon the allegations in the complaint. There's a lot of discussion in the briefing about extrinsic evidence. We can talk about that if you'd like, but I think the main point here is that just based upon the four corners of the complaint, the claim that was alleged, there was no coverage and no duty to defend that. Again, Ortez didn't pay any defense cost. He actually answered on his own request for admissions in the tort case where he admitted to reckless, willful, wanton conduct, which is the standard that he had to admit to in order for the Pleasant claim to apply and the judgment to be entered against him. And so that claim, that breach of contract claim, is now, as we started the discussion this morning, Your Honor, moot because we've now paid that. Now, the truly, I think, breathtaking part of the trial court's order from 2019 that...
Let me ask you one other question.
Yes, sir.
Did the jury award punitives based on the willful wanton?
There was no jury trial in the underlying case.
So it was a settlement.
It was a summary judgment, actually.
Okay.
And there were no punitive damages. It was compensatory damages.
So you didn't have a choice between the punitive damages and the unfair and deceptive, correct? That wasn't an issue at all.
Yeah, so I want to make sure we're speaking apples to apples. In the underlying wrongful death case that was Estes versus Ortez, there was a summary judgment order in favor of the plaintiff that Ortez was recklessly willful, wanton, negligent because he answered requests for admissions that way. And then the trial court entered summary judgment awarding $9.5 million in compensatory damages to the estate. In the coverage case...
So make sure I'm correct. The issue of damages was never submitted to the jury whatsoever.
There was never a jury trial in either case.
Okay, so it wasn't just liability, because I know you can bifurcate.
Correct.
So the entire matter was before the trial court.
In the wrongful death case, correct. It was all resolved as a matter of law on Rule 56 motions for summary judgment, and the court entered compensatory damages on that basis. Okay. In this coverage case that brings us here today, we never even got to summary judgment. The court entered this judgment based on Rule 12C, which is the gravamen of what kind of candidly brings us here today in terms of the dollars involved, because the trial court got from $1 million to $9.5 million to $28 million, we would submit A, improperly and contrary to the law, and B, without the benefit of any discovery, much less a trial. And this court has to, if nothing else, remand for that to take place. I see I'm kind of getting to my rebuttal time. I'll say a couple of quick things. On the question of the getting from $1 million policy limit in the trial court saying that doesn't matter, you're liable for the full $9.5 million, that's contrary to the Jamestown case, the Ames case. I would point this court directly to the Ames case, which is a situation where there was an insurer that failed to defend. There was a settlement of $5.2 million. The court found that the carrier that failed to defend did so wrongfully and ordered them to pay $1 million policy limit. Not 5.2, not even half of 5.2, but in order them to pay the $1 million policy limit, plus half of the defense costs that had been incurred by another insurer. There's simply no basis in the law or fact, and certainly not on a Rule 12c motion, to say a mere breach of the duty to defend without a fact finder finding anything more that was done in bad faith or otherwise somehow weighs the policy limit and turns a $1 million policy into a $9.5 million policy. And then the second thing is, under the BB&T versus Thompson cases, this court is well aware there has to be a finding of substantial aggravating circumstances in order to award damages under Chapter 75 and treble those damages. And furthermore, under the Gray case from our Supreme Court and Chief Justice Frye's opinion from 2000, there has to be a finding of damages proximately caused by the unfair act in order to establish those damages. Penn National never had a chance to deal with any of that here because the trial court resolved all this on Rule 12 motions without any sort of discovery, much less a trial. And we would ask the court to reverse and remand on that basis as well. I'll reserve, looks like I've got about 5 minutes left, not 7, but thank you very much.
Thank you. Since the court asked several questions, we'll give you your full 7 minutes on rebuttal if you need it.
Thank you, Your Honor.
Okay? Hear from the appellee.
May it please the court, David Stradley from the Wake County Bar on behalf of plaintiff appellee Louis Ortez.
Let me ask you do you agree with the summary of the status of the issues that are before us right now?
It will not surprise you that I do not. And so let me go right there, and then I'll sort of come back to why I think this is an important case for the jurisprudence of North Carolina, and not just, in this case, individually. We stand by our motion to strike and our response to the motion to supplement the record as that being improper, but since that response has not yet been stricken, I do need to address it. We do not think anything has changed in the case other than the fact that Penn National has now admitted its wrongdoing. We have claimed all along that Penn National should have defended this lawsuit against Mr. Ortez, which coincidentally was brought by one of the most fearsome plaintiffs' firms in the state, the Abrams Law Firm, was very familiar to Penn National. We contend they should have defended it and they should have settled it. And now, 6 years later, they finally decided to do the right thing in that regard. But to answer your question, Judge Tyson, that doesn't change a thing in terms of where the case stands, and here's why. Of course, this issue hasn't been briefed because Penn National waited until the 11th hour to make this ploy. But if we could go to the screen, Madam Clerk, this court has addressed what happens when a defendant in an unfair trade practices claim comes up way more than a day late and tries to settle the contract, tries to pay the contract damages. And there are several cases, but I'll just talk about 2 of them. The first is Garlock versus Henson. And in Garlock, what happened was there was a contract for, I believe, a backhoe or a front-end loader or some sort of piece of construction equipment, and and the contract was basically, I'll pay you when I get it sold. I'm going to sell it and I'll pay you. The defendant says to the plaintiff, and the defendant sells it and doesn't give the money to the plaintiff. And the plaintiff sues, alleges unfair trade practices, and then the defendant says, oh, you can have your money now. And here's what court says. This court. Defendants attempts to divide this case into two distinct occurrences as if the breach of contract is separate from the conduct which aggravated the breach, when in fact we have a continuous transaction that amounts to unfair and deceptive trade practices. It does not matter that the same set of facts also constitutes a breach of contract where the same course of conduct gives rise to a traditionally recognized cause of action, as, for example, an action for breach of contract, and as well gives rise to a violation of GS 75-1.1. Damages may be recovered for either the breach of contract or for violation of 75-1.1.
Counselor, may I ask a question? Where is the responsibility or the duty if there is in fact an exclusion clause?
Well, I'm happy to talk to you about that as well. And then I'll come back to this issue about the settlement. So under North Carolina law, we have the Four Corners rule. Again, Waste Management versus Peerless from the Supreme Court, and also the Strickland versus Hughes case from the Supreme Court, as well as the Buzz-Off case authored by Chief Justice Newby. And the idea is you compare the four corners of the complaint to the four corners of the policy. And if those things are even arguably covered, this is Cubitt versus Mag Mutual, it says an insurer is excused from its duty to defend only if the facts are not even arguably covered. And there is a co-employee exclusion here. But the fact of the matter is, Penn National relied on information outside of the pleadings to deny the duty to defend here, which is impermissible. In fact, the Supreme Court in Strickland versus Hughes addressed exactly this situation. Exactly this situation. What happened in Strickland versus Hughes, here's the allegations. The plaintiff alleged that he was a passenger in a vehicle and that the defendant was driving. That's the first block there at the top. And then it goes on to say Aetna, the insurance company, Aetna's investigation of the wreck, quote, conclusively reveals, unquote, that the plaintiff was in fact the driver and the defendant was the passenger. And there was an allegation of collusion. And what happened was the insurance company wanted to intervene and litigate these issues. And the Supreme Court says, can't do that. Can't consider that information because once the allegations of the complaint brought the claim within the coverage of the policy, the obligation to defend is absolute. And it says, the court says, and I quote, it becomes absolute when the allegations of the complaint bring the claim within the coverage of the policy. Now, my colleague said something that I'm afraid just doesn't quite square with the language of the complaint. He said that the complaint says this claim is brought under Pleasant versus Johnson. That's not so. If we could go back to the monitor, I'll show you the page of the complaint. This is paragraph 100, page 100 of the record, and we see several things on this complaint, on this page of the complaint. First of all, it says, fifth claim for relief, reckless, willful, and wanton conduct by defendant Louis J. Ortez. This is the underlying wrongful death lawsuit complaint which my client got sued. First of all, you will note that the heading of the complaint does not say Pleasant versus Johnson. It doesn't say claim against co-employee. It says reckless, willful, and wanton conduct. Now, in North Carolina, as you well know, we have alternative allegations of pleading. Rule 8 specifically allows allegations to be pled in the alternative, and we have notice pleading. And so the only thing that the defendants are hanging their hat on and used to justify leaving my client undefended in a wrongful death lawsuit is paragraph 53 of the complaint, which in fact, the discovery has revealed they did not rely on. They actually relied on their own investigation, which they can't do, but if we go back, I guess we can talk about that. But all they say, that they're 100% reliant on paragraph 53, which says defendant is liable to plaintiff based on the legal precedent of Pleasant versus Johnson, and subsequent legal authority in North Carolina recognizing that legal duty and that legal right of recovery. Well, what does Pleasant versus Johnson talk about? Yes, it does talk about liability to a co-employee, but it also talks about a lot of other things. It talks about what constitutes wanton conduct. We have described wanton conduct as an act manifesting a reckless disregard for the rights and safety of others. That's in Pleasant versus Johnson. It talks about Prosser and Keaton on torts. It talks about reckless conduct. The definition of reckless appears to be merely a synonym for wanton and has been used in conjunction with it for many years. And it further talks about whether wanton and reckless behavior may be equated with an intentional act for certain purposes, and it goes on to talk about punitive damages being able to be recovered for intentional torts and willful and wanton conduct. And in fact, these are the things that are being sought in the claim against Mr. Ortez. So to suggest that in light of Cubitt, in light of this court's precedent in Cubitt, where an insurer is excused from the duty to defend if the facts are not even arguably covered, to say that that including 2 words and a letter, Pleasant v. Johnson in the complaint, triggers an exclusion when, as Mr. Brown concedes, there is no allegation of co-employment in the complaint, is a mighty thin reed on which to excuse the duty to defend. And in fact, neither of our courts have ever allowed anybody to do that. And in fact, and echoing the holding of Strickland versus Hughes, saying that you can't consider matters outside the complaint, is a case from the Western District by Judge Voorhees, New NGC versus Ace American, where the court says, where the complaint fails to assert claims falling within the coverage, which is not the situation we have here. We have asserted claims falling within the coverage. An insurer's duty to defend may still be found where the insurer knows or reasonably could ascertain facts that, if proven, would be covered by the policy. Then the court goes on for the important part. However, the inverse of this inquiry has not been recognized by North Carolina courts and has been explicitly rejected by the Middle District in a decision affirmed by the Fourth Circuit. And there, the Fourth Circuit says, or the Middle District says, once a complaint implicates the possibility of coverage, an insurer may not exonerate itself by preliminarily determining that no coverage actually exists despite the allegations of the complaint. And it says, permitting evidence outside the pleadings to negate the allegations in the complaint is akin to a perfunctory review of the merits of the underlying claim against the insured. Such a review is not consistent with the duty to defend as understood by the insured party and as explained by North Carolina law pertaining to interpretation of contracts of insurance.
But, Counselor, you're asking us to not give so much weight to 2 words and an alphabet V, but you're not telling us what you want us to do with the exclusion clause.
Well,
Are you asking us to ignore the fact that the contract has an exclusion clause?
The contract has an exclusion clause, Your Honor, but it's never triggered. For there to be an exclusion, there have to be facts that trigger the exclusion alleged in the complaint.
Where is that in the contract that talks about it has to be ignored or triggered some kind of way?
Well, if you look at the waste management case that Mr. Brown referred you to, the Buzzoff case, there has to be, where the complaint otherwise alleges a covered claim, there have to be allegations in the complaint that trigger the exclusion.
But you cited Pleasant v. Johnson, which
Right.
triggered us to look at Pleasant v. Johnson in its entirety, all four corners of the document. Of
You don't look at the four corners of Pleasant v. Johnson. You look at the four corners of the complaint and the four corners of the policy. And my point about Pleasant versus Johnson is simply that Pleasant versus Johnson stands for more than one proposition.
But it stands for the main proposition, which triggers that this was an employee-to-employee complaint.
It might stand for that proposition. It might stand for something else.
Isn't that the only way? Isn't Pleasant versus Johnson the only way outside of workers' compensation that the claim could even be asserted?
Perhaps.
Yes or no? I mean, up until, let me ask you this way. Up until Pleasant versus Johnson, did a co-employee have a right to assert a claim outside of workers' comp? I guess
No,
they
Your
would.
Honor, but...
Okay, no.
Correct.
All right. So going back to Judge Thompson's question, it is Pleasant versus Johnson that allowed the claim to be brought anyway.
Well, let me...
Yes or no? Yes.
No.
No.
And here's why. Because the workers' comp immunity is an affirmative defense. And so you can bring the claim, and if and law is clear in North Carolina, if an affirmative defense is never asserted, it's waived.
Well, let me ask you
And that's
this.
why, that is precisely why, Your Honor, that my client has a judgment against him, because nobody ever showed up to defend him to assert this affirmative defense.
Do you agree that defendant's liability here is derivative versus direct?
No, I do not agree with that. If what you mean is the defendant's, is Penn National's liability derivative? No, Penn National's directly liable under the contract that it made and for unfair deceptive trade practices, if I'm understanding the court's question correctly.
Well, I guess what I'm saying is if you have derivative liability, if it is derivative,
Derivative of what, Your Honor? I'm not following.
basically, they did not directly insure the driver. They insured the driver's employer.
Actually, that's not correct, Your Honor. And I think Mr. Brown conceded the fact that he was not the named insured, but he was an insured, and therefore that's not derivative liability. They're not liable to him because they're liable to the employer, who's then liable to him. They're liable directly to him because he falls within the definition of an insured. He's simply not the named insured. So he has a direct contractual relationship with Penn National.
So how could the defendant be liable in excess of the limits of the obligation they contracted for?
Well, if you look at the Jamestown Mutual case from the Supreme Court, Your Honor, it says that an insurer who wrongfully refuses to defend a suit against its insured is liable to the insured for sums expended in payment of the claim, payment or settlement of the claim for reasonable attorney's fees and for other expenses incurred because of the refusal of the insurer to defend. And so that's important. That "and" is important. It is not merely it doesn't say is liable for the claim up to the policy limits. It says it is liable for payment of the claim. And here's why that's important, Your Honor. Here's why that's extremely important. If it were otherwise, that an insurance company could not defend and still assert its policy limit, why would they ever defend a case which exceeded their policy limit? Why not simply keep the money in their pockets? Because these lawyers are expensive. Why not keep the money in their pockets for the defense? Don't defend, let the plaintiff have their way, get a judgment for millions and millions of dollars, and then they come in and say, oh, sorry, here's our policy limit.
I think the law is fairly clear that the insurer has a greater duty to defend than a duty to indemnify.
No question, Your Honor.
So I think that's well settled. But again, when you go back to the Buzzoff case that Chief Justice Newby authored, there seems to be a duty, a correlation to look at the claims in the complaint, look at the policy, and make a determination. So I want you to respond to the counsel's argument also that whether or not Buzzoff is met requires a fact determination that was not done at a 12C motion.
Your Honor.
Why we should not send it back for that factual determination to be made.
Well, two answers to that question. First is, it is a straight comparison test. And if you look at the record, if you look at the admissions in the answer, they have admitted this is the complaint. They have admitted this is the policy. At that point, it is a legal question. The judge compares the two, and in fact, duty to defend cases are, I would hazard, usually, if not almost always, decided at the pleading stage. Because it is a straight legal determination of what is the complaint, and it is what it is. It was filed in court, no question about it. What is it? And what is and what does the policy say? And because it doesn't matter if the allegations in the complaint are true, as Justice Newby says. It doesn't matter if they're true. They could be frivolous. There's still an obligation to defend. That brings me back to why this case is so daggone important in the jurisprudence of North Carolina.
Well, before you go there, going back to Judge Thompson's question, they've received notice of the claim, they've got a policy, they've got a complaint.
Yes, sir.
They're looking at both.
Yes, sir.
And presuming the reference to Pleasant put them on notice that this was an employee-based willful wanton claim. Presume that's true. You've got a policy provision here that says that is excluded from our liability.
Well, that's correct, except that that's a void exclusion, Your Honor, and here's why. This policy, this is an auto policy. This is not a homeowner's policy. This is not a CGL policy. This is an automobile liability policy. And as the court knows, automobile liability policies are subject to the Financial Responsibility Act. And under the Financial Responsibility Act, 20-279.21 B2, a carrier has to insure anyone using the vehicle with permission. And that's Mr. Ortez. They admit that. They admitted that here today. They've always admitted that. Mr. Ortez was using the vehicle with permission, and he is anyone. The Financial Responsibility Act does not allow an exclusion for liability of a co-employee up to minimum limits. And I guess I do have to pose this question, Your Honor. If they're right, if everything that Mr. Brown has said is correct, why did they pay? If they never had a duty to defend, if they believed they didn't have a duty to defend, if they never had a duty to settle, why did they pay an $8.5 or $9.5 million judgment 2 days ago? The fact of the matter is, this is all trying to backfill and justify a bad decision that they made a long time ago. Otherwise, they wouldn't have paid it. And so, the language of the policy, Your Honor, says we don't have a duty to defend claims to which this insurance does not apply. Well, as the court knows, the Financial Responsibility Act is read into every auto policy. And when you read into this policy, the Financial Responsibility Act, which voids the co-employee exclusion, there was a duty, the policy applied to Mr. Ortez, because their only argument that it didn't apply is this co-employee exclusion. And the co-employee exclusion is absolutely void. It used to not be void. There used to be 20-279.21E used to allow this, and we briefed this point, but the legislature amended 20-279.21E and took that exclusion out. And now that section has to do with the interplay between workers' comp and uninsured motorist coverage. So there was at least up to minimum limits, up to the $30,000, which, by the way, the estate offered to settle for. Up to the $30,000, the exclusion was void. And so even if the complaint triggered, even if that slight reference to Pleasant v. Johnson in one paragraph of the complaint, even if it did trigger the exclusion, that exclusion had no application to the claim up to the $30,000. And they didn't defend any of the claims.
Did Judge Nobles make a determination of the validity of the exclusion?
No, I don't think Judge Nobles addressed the exclusion, but that doesn't mean that you can't address the exclusion, because any ground to uphold the claim, this court can uphold the judgment of the trial court on any ground whatsoever. And I don't think Judge Nobles spelled out his rationale. He simply granted the judgment on the pleadings, which I believe, under this court's precedent, is the correct way to do it. I think the court has directed the trial court not to make specific findings on pleadings motions. But I do want to circle back to the reason this case is so important for the jurisprudence of North Carolina. Small businesses, school teachers, deputy sheriffs like my client, large businesses, churches, schools, appellate judges, lawyers, doctors, we all live in a risky society, and we all have to buy insurance. And one of the risks we run is the risk of getting sued. We might even get sued frivolously. But the important thing about insurance policies, particularly liability insurance policies, is that they contain a duty to defend. We don't think about that in our daily lives, that, hey, I've got this insurance that's going to hire a lawyer to defend me, but the reality is, and I don't need to tell three lawyers, that having a defense in a court of law is a very valuable thing. In this case, assuming Mr. Brown is correct, we've got co-employees. If you look at the allegations of the complaint against my client, they weren't sufficient to actually amount to a Pleasant claim. All they had to do was get a lawyer to come in, and my client wouldn't have a judgment against him at all, because if it is only a Pleasant claim, if they're right, it's only a Pleasant claim, then it would have failed, because the allegations simply don't rise to the level of a Pleasant claim. As Mr. Brown correctly points out, it is a very narrow exception, and mere distracted driving does not get you there, and that's all that's alleged in the facts of the underlying complaint. So it is extraordinarily important that we apply the duty to defend as our Supreme Court has defined it, and not to let insurance companies pick fights with their insureds, go outside the insurance contract looking for information on which to deny the claim. And I think, if the case goes back, the evidence is going to be they didn't, in fact, rely on the Pleasant versus Johnson claim. They didn't even know what it was. What they relied on was information outside the four corners to deny the defense, which is entirely improper. But the fact of the matter is, the judge got it right in the first instance. Pleasant versus Johnson is not sufficient to trigger the exclusion. Even if it were sufficient to trigger the exclusion is void because it conflicts with the Financial Responsibility Act. And the policy's own duty to defend says we have a duty to defend the claims to which this insurance applies. And if you read the exclusionary language, it says this insurance does not apply to fellow employees. And again, under 20-279.21, that exclusion falls out. So the only exclusion that they have is void. And therefore, they had a duty to defend the claim to which it applied. I do want to circle back to this notion where we sort of started, this notion of why their settlement doesn't constitute anything other than an 11th hour admission of wrongdoing. And this is Vasquez versus Allstate. And Vasquez versus Allstate was a UM case in which the plaintiff had claimed uninsured motorist benefits as well as unfair trade practice benefits, or as well as asserting an unfair trade practice claim. And the case was bifurcated or trifurcated or something. In any event, the uninsured motorist claim got tried first. And the jury came back in favor of the plaintiff on the uninsured motorist claim. And then the insurance company, Allstate, said, okay, you got us. We'll pay you our $100,000. Game over, no unfair trade practice. That's what the insurer said. And the Court of Appeals, this court, said no. They said that the Garlock holding makes clear that the right to receipt of contract damages does not eliminate plaintiff's injury under the unfair and deceptive trade practices claim. We hold that it makes no difference whether the right to contract damages arises from a favorable jury verdict, as in Garlock, or from a stipulation after a jury verdict, as happened here. Accordingly, we hold the trial court correctly allowed the jury to consider the contractual damages as an element for the unfair and deceptive trade practices claim.
So what are the damages?
The damages are the amount of the judgment. And that's exactly what they did in Garlock, and that's what they did in Vasquez. The court said the damages are, the contract damages, trouble.
But they've already paid that.
And maybe they haven't paid it in this case. They paid it in some other case. They didn't pay it in this case, such that there will be a credit against the judgment in this case. So it's arguably a collateral source. But even if it is, even if they get credit for it, okay, they get credit for it. You know, it's trebled. These cases stand for the proposition, Your Honor, that you don't not treble it because they come in late and pay it. You still have to treble it. If they get credit, maybe they get credit for it, maybe they don't. Maybe that's a question for another day. But the fact of the matter is the damages are the damages, and you can't retroactively erase the damages by paying them late. Certainly not 6 years after the fact, and 5 years after a judgment has been entered against you, or 4 or 5 years after a judgment has been entered against you for the unfair trade practice damages, which is exactly what they did here today. So, they don't get a time machine. They don't get to go back in time and say, we did no wrong. They've done wrong. If you read Garlock, and I appreciate the court hadn't had the benefit of briefing on this, but if you read Garlock and if you read Vasquez, I think you'll conclude that the point is that even if they pay the single damages, we still get the treble damages, and therefore the trial court's order should be affirmed. And I thank you. Happy to answer additional questions, but I believe my time's up.
Just a minute. Okay. Thank you, sir.
Thank you, Your Honor.
Mr. Brown, we have rebuttal.
Thank you, Your Honor. May it please the court.
Before you start, let me ask you to specifically address the point of Vasquez and Gray.
Sure. The first thing to notice about Vasquez and the Garlock case that counsel mentions are that there was a jury trial. There was a trial where the jury was presented evidence. Garlock's not even an insurance case. Vasquez at least was an insurance case, but there was a trial where the parties got to put on evidence. The jury decided that there was a breach of contract. They then, in phase 1 and phase 2, they said that there was an unfair trade practice and assessed damages proximately caused by the unfair act. Then in phase 3, they said no bad faith, and this court affirmed. I don't find that very shocking or strange. They got a trial, and the jury said these are the damages proximately caused by the unfair act, which is what the Gray case from the Supreme Court says should happen. We never got even discovery, much less a trial.
Let me ask you this. Do you, going back to the buzz-off case that Chief Justice Newby wrote, is the determination of a duty to defend, is that a question of law or a question of fact?
It is a question of law.
Okay, so to counsel's point, you look at, the way I read Buzz Off, you look at the complaint, you look at the contract, and you make a determination from there.
I agree. I think the only thing that was proper for the trial court to do on Rule 12C, and frankly, the only thing proper for this reviewing court to do, is to decide whether there was or was not a duty to defend based on the precedent in Hardeesville versus Buzz-Off and Waste Management and the documents.
Is there any difference from the duty to defend? Is there any difference that the named insured, I think you've agreed that the individual wasn't insured, but not the named insured. If a named insured is not listed as a party to the case, not on the complaint, does that alter the duty at all?
No, the duty still attaches to someone who qualifies by definition.
So the burden is on your client to look and see if a party named, regardless if your named insured is not named, it's your duty to look and see if there's potential liability or indemnity coverage for that party, correct?
Correct, and Penn National did that. I mean, we've talked about a lot of things that were not before Judge Nobles, which is one of the reasons this should be remanded, but Penn National did that and determined that Mr. Ortez and Mr. Estes were working. They both got workers' comp. They were in the course and scope of their employment. He is an insured. The basis of the denial was not that he was not an insured. The basis of the denial was the fellow employee exclusion because of the Pleasant claim. And to answer Your Honor's question, yes, I think Ortez wants you to ignore that exclusion in the policy.
Do you, how do you respond to counsel's argument that the exclusion is void?
So,
The change in the statute.
yeah, so he argues that the exclusion is void based upon the Financial Responsibility Act. And my response to that is that this court has been very clear that the Financial Responsibility Act does not impose a duty to defend. Repeat, does not contain a duty to defend. It's in the Hardeesville versus Zurich case. It's discussed at length at pages 13 through 15 of our reply brief. And let me just back up and say this. The Financial Responsibility Act protects those who are injured. Usually when this court sees Financial Responsibility Act questions, it's uninsured, underinsured motorist questions, right? Because those are protecting the individual. In the context of liability insurance coverage, what the Financial Responsibility Act says is that the insurance carrier, even if an exclusion applies, has to pay minimum limits, which are now $30,000, to the injured party. It's about protecting the injured party. It's not about protecting Mr. Ortez as the driver. That comes via contract. So this court said, the Financial Responsibility Act does not impose on the insurance company a duty to defend, period. And I'll add as a footnote,
Which case is that? I'm sorry.
Hardeesville versus Zurich. It's discussed at pages 13 through 15 of our reply brief, and the site is 157 North Carolina App 317. It's a 2003 case. If you look at that case, you will see that I lost that case. So I know I've been litigating these issues for a long time. This was over 20 years ago. My client was an insurance company that defended a case and said, I represented Hardeesville, and we essentially said the other insurance company should have also defended because of the Financial Responsibility Act. And since they didn't defend, they owe us some money. And what this court said was, that's a good argument, Mr. Brown, you're correct. The Financial Responsibility Act does mean they have coverage, but because the Financial Responsibility Act does not impose a duty to defend, they don't have to reimburse your client for any defense cost. And furthermore, all they owe is some indemnity up to $30,000. They haven't waived their policy limits and owe the full amount you paid, which was a 7-figure number, et cetera. So I would commend that case to you. But I think this court was very clear and has been very clear that the FRA does not impose a duty to defend. And I guess I'll leave the court with this. Why pay? That question's kind of been thrown out there. We admitted fault. Well, I mean, the settlement Estes, not confidential. I'm glad to tell the court what it is if you want to know, but suffice it to say, it was a compromised amount, much less than what Estes wanted, and much less than the judgment, and much less than what they had been demanding, and more than we wanted to pay. But just like a trial date kind of brings people to the courthouse steps to talk settlements more seriously, a date with this court brings parties together to talk settlement a bit more seriously, and that's what happened in this circumstance. It was by no stretch of the imagination an admission of fault or anything else. And so I leave the court with this. The truth matters. I mean, I know that states the obvious, but we sit under the esse confidere sign, which I always look at every time I'm in court. The truth matters. And what we know is that Ortez and Estes were, in fact, co-employees. There's no dispute about that. What we know is that Ortez has now been released and fully discharged, and no judgment is pending against him. There's no dispute about that. So we ask this court to reverse the trial court's order, find in favor of Penn National that there was no duty to defend, reverse all the remaining findings against Penn National in the judgment, or in the alternative, to remand it to the trial court to conduct discovery and proceed with the case that was stopped very prematurely under Rule 12C. Thank you, Your Honor.
Thank you.
Thank you for your time.
Thank you both very much for good arguments, and the case is submitted. Madam Clerk, will you please adjourn court?
All rise. This court is adjourned.
Thank you for your help.
Yeah, we'll see you soon.
Yeah.